Good day, Crime Talk aficionados. We have another great show for you today. First, the former FBI director, James Comey, pleads not guilty to federal charges from the 2020 congressional testimony that he gave, where the prosecutors say he lied. Former NFL quarterback Mark Sanchez faces up to 16 years in prison. A Florida dentist got a little toe tantrum, steals the spotlight from his murder rap. We've got a story of a random act of violence. A middle school teacher jailed for doing terrible things to a 15-year-old girl is killed in prison. David, spelled with a 4, we got an update on his case. The ex-Southern Charm darling, Kathryn Dennis, well, she's in jail for a DUI. And oh, look who's back in the slammer, a former official. Flops on probation. We got this day in legal history, our quote of the day, and our dumb criminal. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reisch, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Before we get to the docket, let me remind you, go to crimetalksearch.com. Sign up for that background subscription service today. When you do, you'll be able to do a background search on anyone here in the United States, as many people as you desire. So if you want to, be a home detective, dig in deep to all these potential witnesses and the cases that you're following, this is the place to do it. Or maybe somebody's coming into your life, or maybe you're thinking about having somebody exit your life because you're just not getting that warm, fuzzy feeling. Go there, sign up. The report is literally prepared while you wait. It's emailed to you. You can get updates, and you're going to find out information regarding telephone numbers, email addresses, social media presence, liens, judgments. Are they married? Are they divorced? Do they have a criminal history? Are they a sex offender? Everything you want to know about somebody coming into your life, go to crimetalksearch.com. All right. Also, we gave these out. We gave these out at a CrimeCon. Everybody wants one. And guess what? They're flying off the shelves like hotcakes. If you want one, you better go get them now. One, only $5, ladies and gentlemen. Go check it out when you go to the link. Also, and if you haven't got your baked in Colorado CBD dog treats, if you love your animal like everybody does, you want to give them the best. CBD, right? They take out all the bad stuff and they give nothing but the good stuff. CBD dog treats baked in Colorado. Same page in the link below. All right, let's go ahead and get to the docket for Wednesday, October 8th, 2025. And first on the docket, former FBI Director James Comey goes to court. That's right. Former FBI Director James Comey. And this is kind of a big deal, ladies and gentlemen. And we're not getting political. But when the former head of the FBI, the top law enforcement branch of the United States government, gets charged with lying, that speaks volumes. Okay? And, deep down in your heart where maybe you don't like to go, even if you're like the FBI, kind of gives you a little bit of pleasure that somebody in that position of power, guess what? The law applies to everybody. Something to remember. So, former FBI Director James Comey entered a not guilty plea today in federal court to charges of making false statements and obstructing a congressional investigation. The arraignment held before District Court Judge Michael Nashmanoff in the Eastern District of Virginia marks a significant escalation in a case initiated by the Department of Justice, and some say under the pressure from President Trump. Now, Comey requested a jury trial and entered a plea of not guilty, which is pretty much automatic. And the judge scheduled a jury trial to commence on January 5th of 2026. Now, the proceedings underscore some ongoing tensions between Mr. Comey and the president, Mr. Trump, dating back to the FBI investigations into the Russian election interference during the 2016 presidential campaign. So Comey, he arrived at the federal courthouse through a side entrance, avoiding the perp walk. He was never arrested. He appeared on a summons. I never get my clients to appear on a summons. Sounds like a little preferential treatment already, does it not? Anyway, went through the side door to avoid the media scrutiny and remained silent during the reading of the charges. His legal team entered a not guilty plea on his behalf, a standard procedural step that allows the defense to contest the allegations without conceding their validity, obviously. Now, it's anticipated that there will be an aggressive defense strategy, potentially including motions to dismiss the indictment on grounds of selective or vindictive prosecution. Probably Exhibit A will be the president's tweet saying, why is he not being charged? And then coincidentally, just a couple of days later, he gets charged. But also, the statute of limitations was running as well. And guess what? It's kind of up to the independent grand jury, who apparently indicted on 2 counts, but not a 3rd. So you can't say that they were biased or prejudiced in any particular way. And given the fact that it is a very Democratic stronghold in that area as well, the fact that he got indicted means the grand jury was simply following the law. And remember, its indictment only requires a probable cause. They basically, more likely than not, that the defendant, Mr. Comey, committed a crime, right? Very low standard of proof. Obviously, a trial, the proof is proof beyond a reasonable doubt, but it's a lying charge. Okay? Here's the statement. Here's the evidence why we believe he lied. Pretty straightforward in most circumstances, but obviously we'll see how this plays out, and Mr. Comey is entitled to that presumption of innocence. So the charges against Comey originated from his September 30th, 2020 testimony before the Senate Judiciary Committee. And that was conducted remotely from his Virginia home during the COVID-19 pandemic. Now, during the hearing, Comey reaffirmed statements from his May of 2017 congressional appearance where he denied authorizing any FBI personnel to serve as an anonymous source in media reports about the Bureau's investigation into Hillary Clinton's email server or potential ties between the Trump campaign at the time and Russia. Now, prosecutors allege that this reaffirmation was knowingly false, citing evidence that Comey had authorized leaks. Specifically, there's a 2018 Department of Justice Inspector General report that referenced statements from Comey's former deputy, remember, Andrew McCabe, who claimed that Comey approved him to provide information to the press. Now, remember, ladies and gentlemen, the threat of imminent incarceration tends to break the bonds of loyalty. Even if Mr. McCabe was a trusted, deputy at the time, he doesn't want to go to jail. And so he presumably told the truth and said, but I was authorized by the director himself to leak this information to the New York Times. So more than likely, his trusted aide at the time, Mr. McCabe, Andrew McCabe, will be witness number 1 against him. Additionally, the case involves Comey's testimony regarding his awareness of an unverified intelligence report suggesting that Clinton sought to fabricate a scandal linking Trump to Russia. Prosecutors contend that Comey falsely claimed no recollection of the report. That's going to be a little tougher to prove because he could say, I didn't know it. I read lots of reports. That'll be the more difficult one to prove probably for the prosecution. So the indictment was returned by a federal grand jury on September 26th, just before the 5-year statute of limitation expired for the 2020 testimony. Notably, the 2017 statements fall outside this window, leading prosecutors to focus on Comey's 2020 reaffirmation as the basis for the charges. Now, the United States attorney, a former Trump attorney appointed to the Eastern District of Virginia, announced the indictment, emphasizing the need for accountability in congressional oversight. So testimony from a Columbia law professor, a guy by the name of Daniel Richmond, whom Comey has acknowledged authorizing to share memos about his interactions with Trump, could pose challenges for the prosecution. Reports indicate that Richmond's involvement might create insurmountable problems in proving intent, as it could highlight ambiguities in what constitutes an authorized leak versus anonymous sourcing, which is interesting because, as the director of the FBI, you're not supposed to release anything to the public that you're not supposed to, and you don't get a pass because you're the director. But of course, everybody's known about these potential leaks for years, and obviously, the Biden administration didn't bring it, and now the Trump administration is bringing it, and so it looks political. Obviously, if everybody knew about this type of information early on, you would think that the Biden DOJ would have indicted him if the law applies to everybody? Or is there really a two-tier system of a legal system as it relates to the rich and powerful and, everybody else? So let's talk about the indictment. Comey faces 2 felony counts under federal law, making a false statement under 18 United States Code Section 1001. And this charge alleges that Comey knowingly and willfully made a materially false statement during his 2020 testimony. Prosecutors claim he lied when responding to Senator Ted Cruz's question by stating, "I stand by the testimony you summarized that I gave on May of 2017 regarding leak authorizations." The indictment specifies that this affirmation obstructed the committee's inquiry into the FBI's handling of sensitive investigations. Then we have the obstruction of congressional proceedings, 18 United States Code 1505. This count accuses Comey of corruptly influencing or impeding the Senate Judiciary Committee's proceedings through false and misleading statements, and the obstruction charge ties directly to the alleged false affirmation, asserting that it hindered congressional oversight of the executive branch's actions. Now, the indictment is notably sparse, providing limited details on the precise falsehoods or evidence of Comey's intent. If convicted, Comey could face up to 5 years in prison per count, though sentence in similar cases often consider such factors as a lack of prior criminal convictions and the non-violent nature of the offense. So, the other thing is speedy trial. Speedy trial in the federal system is much faster than it is in the state, but there's a couple of exceptions, all right? So we have a trial date set now for January 5th of 2026, which complies with the Speedy Trial Act of 1974. And that federal statute is designed to protect defendants' Sixth Amendment right to a speedy trial while ensuring the efficient administration of justice. A requirement is that the trial commence within 70 days of the defendant's indictment or initial court appearance, which is the arraignment today, whichever is later. Now, there's exclusions for certain delays, such as those caused by pretrial motions, continuances granted in the ends of justice to allow adequate preparation, or complex case designations. Now, sanctions for violations, including potential dismissal of charges with or without prejudice. Don't worry, they're going to get him to trial. More than likely, the defense will file a motion for an ends of justice continuance or complexity based upon the amount of discovery that is out there. Most of it's probably not particularly relevant. Comey knows what he said. The transcript speaks for itself that he made this reaffirmation. His McCabe deputy, Andrew McCabe, knows what he's going to testify to. Frankly, this case should go to trial by January 5th, but I would anticipate the defense trying to drag this out as long as possible. There may be a lot of voluminous discovery, but in reality, it's probably not going to be relevant. Frankly, if I was Comey, I'd be like, charge ahead, see you in trial on January 5th. So in this instance, the indictment was filed on September 26th and the arraignment occurred on October 8th, starting the 7-day clock from the latter date. And the January 5th date falls approximately 89 days after arraignment. So I'll show you that they're going to get him to trial if he wants a trial within the speedy trial time clock. The judge, this Natch Manoff emphasized the need for a prompt resolution during the hearing, but acknowledged defense requests for time to review discovery materials and file motions. Potential delays could arise from challenges to the indictment, which would toll the clock under the Speedy Trial Act. If the defense waives speedy trial rights or the court grants a continuance, the timeline would extend further without violation. Now, really, there's not really a waiver. You waive your right by asking for the continuance. But let's say the defense files motions tomorrow. The speedy trial clock stops at that point, and the speedy trial does not resume again unless and until the time that all of those motions that are pending are heard. So, like I said, right now they've got 79 days to get him there to trial. But if they file motions, it gives them a little more time. So they'll set the trial date out after January 5th because there's no motions hearing date yet. So what are the potential challenges to the indictment? Well, they're more than likely going to file a motion to dismiss the indictment prior to trial, leveraging several common defenses in false statements and obstruction cases. First, selective or vindictive prosecution. The argument may center on political motivation, given the case's origin in a Trump-era investigation and the prosecutor's ties to Trump. The courts could require evidence of disparate treatment compared to similar cases or retaliatory intent, which could lead to discovery into prosecutorial decision-making. They could file motions of insufficiency under the indictment under the Federal Rules of Procedure 7C, and indictments must provide a plain, concise statement of essential facts. Some people are going to say that the document is too vague, failing to clearly specify the false statements or evidence of willfulness, potentially violating the due process clause. But that's when a bill of particulars would come in if the defense could not figure out what the false statements were alleged to have been based upon review of the discovery. Somehow I find that a little disingenuous. They're going to file saying there's a lack of material intent. Prosecutors must prove Comey knew his statements were false and intended to deceive. The defense could highlight the ambiguities in the 2020 questioning, exacerbated by remote testimony and technical issues, or argue that reaffirming prior testimony does not constitute a new falsehood. But that's really a question for fact, not a legal question for the judge to resolve, and that's up to the jury to decide. Those are really more defenses, but we're giving you the list of everything that they could possibly argue. Reports indicate that special counsel John Durham, who investigated related matters, concluded evidence did not support charges based upon Comey's memory claims. And of course, then you got statute of limitations issues where they're trying to bootstrap the relying on the 2020 testimony to prosecute a 2017 conduct, which obviously is beyond the 5-year statute of limitations, arguing that the matter is improper. That would be a legal issue, but once again, I think the judge will say, sounds like a jury question to me as to whether it's a reaffirmation. But not up to speed on all of that case law in that particular circuit, so we'll have to basically wait for the judge to rule on any of those issues. And we'll have to wait to see if the defense even argues or raises any of those. They should just say, let's just go to trial and let the jury decide. They'll probably also attack the grand jury. Questions about the prosecutor's solo presentation to the grand jury could prompt challenges, though such motions are rarely successful without evidence of misconduct. They will get a transcript of the grand jury proceedings released, and the grand jury, heard the evidence. You don't get to have a trial in the grand jury. The prosecutor presents what they believe to be the facts in the case. The defense doesn't get to ask questions. The defense doesn't get to present any evidence. That's just the way it is. And obviously, if there was some type of challenge, obviously that would result in a dismissal. Now, this particular jurisdiction is known to be, provide a lot of scrutiny to cases involving allegations of governmental misconduct. Now, these proceedings will unfold amid broader debates on executive accountability and prosecutorial independence. Now, Mr. Comey has maintained his innocence, stating through representatives that the charges are baseless and politically driven. The Department of Justice has kept their mouth shut, saying they let the indictment speak for itself. So what do we know about this judge that's going to be hearing the case? Michael Stephan Nachmanoff. Well, we know he was born in 1968 in D.C. He earned an undergraduate degree from the Wesleyan University and his J.D. from the University of Virginia School of Law. Beautiful campus there, I must note. Anyway, Nachmanoff began his legal career as a paralegal at the U.S. Department of Justice. He later clerked for U.S. District Court Judge Leonie M. Brinkma in the Eastern District of Virginia. And for 13 years, he served as the office in the office of the Federal Public Defender for the Eastern District of Virginia, rising to the position of the office head, where he argued numerous cases as well. Now, in 2015, he was appointed as a U.S. magistrate judge in the same district, serving for 6 years and handling politically sensitive matters, including the initial appearance of Lev Parnas back in 2019. In 2021, President Biden nominated him to the U.S. District Court for the Eastern District of Virginia, where he was confirmed and now serves as a district court judge. Now, this judge has a reputation, is recognized for being very methodical and prepared, calm, independent, and rigorous adherence to constitutional principles. His background as a veteran defense attorney has informed his judicial approach, earning him a reputation for fairness in high-stakes cases. So this one's going to be interesting, ladies and gentlemen. Whether you think it's politically motivated or not, we'll have to wait and see. There's obviously several legal issues that will have to come out, and they'll have to be litigated if the defense raises them, which I'm sure they will. But ultimately, this will come down to a jury to decide whether there was, in fact, a false statement. We'll have to wait and see. It is a interesting legal issue as to whether there's a reaffirmation of your prior testimony from 2017 back in 2020. It is. But you would also think that if you are not going to reaffirm your testimony and say, well, it's been a long time, I'd have to look at my testimony before I reaffirm it. But if you do, then that's it. And then obviously at court, there's going to be lots of cross-examination based upon what question was asked. Did he really understand it? Was it confusing? Goes to intent. Going to get interesting, ladies and gentlemen. Like I said, not often the former head of the top law enforcement agency in the country gets charged with perjury. Whether you like it or not, it's going to be interesting to follow. We'll be following it. I hope you join us. Next, Mark Sanchez, that former NFL quarterback, now faces up to 16 years in prison. That's right. Former NFL quarterback Mark Sanchez is facing significant legal consequences following a violent altercation in Indianapolis during the early morning hours of Saturday. Prosecutors have indicated that Sanchez could face up to 16 years in prison due to the severity of the incident, which left both him and a 69-year-old grease truck driver, a guy by the name of Perry Toll, with serious injuries. Now, Sanchez has been charged with a level 5 felony for battery causing serious bodily injury, which carries a potential sentence of up to 6 years. However, the prosecutor revealed yesterday that the charge could be escalated to a level 3 felony, which carries a maximum penalty of 16 years. The prosecutor explained that the potential upgrade depends on whether the victim's injuries result in permanent or protracted loss as defined under Indiana law. Now, the doctors will help make that final charging decision because they'll have to fill out a form and they'll check the box and say that the victim suffered, serious bodily injury or protracted loss or use of an organ and some injury that results in permanent or protracted loss. That could be a scar. So yes, the charges are more than likely going to be upgraded. Now, according to the arrest affidavit, this whole incident began when Sanchez, allegedly being intoxicated, confronted Toll as he was maneuvering his truck into a hotel loading dock. Toll reported that Sanchez entered his truck, made threats, and initiated a physical altercation. And in response, Toll used pepper spray to defend himself, but Sanchez continued to assault the guy in the truck, causing Mr. Toll to fall into a dumpster and onto a pallet. He was then, fearing for his life, took out a knife and stabbed Sanchez multiple times in the chest with a knife. Sanchez then fled the scene. Witnesses noted that Sanchez appeared to be under the influence, exhibiting slurred speech and erratic behavior, including reportedly running wind sprints in the alley prior to the confrontation. Now, Toll sustained severe injuries, including a significant facial wound, and was photographed in a hospital bed with a neck brace. Sanchez, also hospitalized, was initially detained on charges of battery with injury, unlawful entry of a motor vehicle, and public intoxication. Now, images released on Sunday underscored the severity of Toll's injuries. And on Monday, Toll filed a civil lawsuit against Sanchez and his employer, Fox Sports, seeking compensatory and punitive damages for permanent disfigurement, loss of function, physical injuries, and emotional distress. Sanchez was in Indianapolis to provide commentary for the Colts-Raider game for Fox Sports, but was arrested prior to the event. Nick Sanchez, the former quarterback's brother, issued a statement expressing gratitude for public support and noting that Mark remains under medical care for his injuries. He emphasized the family's focus on his recovery and the ongoing legal process, thanking first responders and medical staff. Sanchez's broadcasting career at Fox Sports, where he started in 2021 after a stint at ESPN. Well, let's say that probably appears in jeopardy. Now, the question is in that lawsuit, was he really employed? Yes, he was there, but was that his official duties in the middle of the night to attack somebody? Probably not, but I get it. Mr. Toll and his attorneys want as much money as possible and go after Fox Sports as well. Anyway, a source with Fox Sports has stated that the incident is considered a career-ending event due to the morals clause in Mr. Sanchez's contract, which obviously his arrest violates that clause. Now, while he has not been officially terminated, the network has already taken steps to replace him on air pending the resolution of his legal issues. Apparently, a lot of people that know Mr. Sanchez are somewhat shocked, who described him, this episode, as being completely out of character. But that's what most people say. But, obviously what happens when you are drunk and you want to get involved in a grease truck driver's maneuvering of his truck, I guess. Just can't make this stuff up, ladies and gentlemen. It can happen to anyone. People don't seem to recognize that, but yes, it can happen to anyone. Next on the docket, Florida dentist, his toe tantrum. That's right. Oh, behold, the plight of Charlie Adelson. Remember him? Florida's most oppressed dentist who bravely survived a toe-stubbing catastrophe at the merciless confines of the Leon County Jail. The self-proclaimed victim of the podiatry injustice, currently serving life for orchestrating the 2014 murder of his ex-brother-in-law, Dan Markle, apparently found the real crime on August 31st. A jail staffer dared to open a door, grazing his precious barefoot toe. Cue the Oscar-worthy meltdown captured on body cam for the podcast Lies and Alibis. That was really effing stupid. Adelson whined because nothing screams I'm in charge like cursing out a nurse while locked in a cell. Now, the 47-year-old mastermind, who clearly thinks he is still sipping martinis at the Ritz, was in jail during his mother, Donna Adelson's murder trial, just in case he felt like gracing the courtroom with his testimony. But instead of reflecting on his role in hiring a hitman to gun down Markle, a Florida University law professor and father of Adelson's nephews, he fixated on his toe. Bring your lieutenant over. I'll tell him how effing stupid you are, he barked at the staffer, because, nothing says I'm a stable genius like demanding to speak to the manager from behind bars. Give me my medicine and open the hatch like a normal person. Like someone with a brain, he added, as if he's the arbiter of jail etiquette. The nurse, unfazed by Adelson's charm, calmly explained to her supervisor that he was just trying to pass meds when Adelson's foot got in the way. He done cursed me out. He done called me stupid, she said, probably wondering why she didn't sign up for a quieter gig, like a lion tamer, perhaps. Adelson, undeterred, rambled about the hatch and how his toe wasn't broken but was effed up, hobbling out of the cell like a Shakespearean tragic hero to demand his meds and a toe inspection. Well, I can tell you there's a lot of eye rolling going on here as people are calling out Adelson's entitlement. That's a sight of an entitled, privileged brat, I say. Now, Adelson, expecting a red carpet treatment apparently in his cell block, he thinks he's still at the Ritz, living his best life out in custody. Now, he needs to sit down, learn some respect, and learn some humility. Many people have said, I agree. Good luck with that. Adelson's rap sheet is juicier than his toe drama. Found guilty in December of 2023 of first-degree murder, conspiracy, and solicitation. He orchestrated the hit on Markle with a messy divorce and a custody battle between Markle and Adelson's sister. Adelson and the then girlfriend, Kathryn Magbuana, hired Latin Kings gang members Sigfrid Garcia and Luis Rivera to stalk and shoot Markle outside of his home back in July of 2014. Garcia, the triggerman, and Magbuana are also serving life sentences, while Donna Adelson, the alleged mastermind, got her own life sentence after a courtroom outburst that earned her a judicial scolding. "Oh my God," she sobbed, as if the real tragedy was her lack of an Emmy for drama. So here's to Charlie Adelson, whose toe injury is clearly the injustice of the century. Forget the murder for hire. It's the hatch that's the real victim here. You can't make this stuff up. This guy really is that entitled. Next in the docket, how about a story about a random act of violence? Let's go to Miami. Let's go to a deli in Miami, to be exact. All right. In a dazzling display of unhinged bravado at a Miami Stop and Shop deli located at the ever glamorous 49th Northeast 2nd Avenue, a 57-year-old man named Gonzalo Gonzalez decided to spice up his Saturday by allegedly waving a Glock, that's a handgun, around like it was a new vape flavor. According to the Miami Police Department's arrest report, this self-proclaimed God from Israel stormed into the deli, plopped his backpack on the counter, and casually asked for a vape because nothing says "I'm here for the nicotine" like a loaded firearm. The store clerk, who had the misfortune of being Venezuelan, claims Gonzalez whipped out the black handgun, racked the slide with theatrical flair, and sent a female bystander diving for cover behind the counter like it was a low-budget action flick. And when the clerk sensibly suggested putting the gun away, Gonzalez complied, but not before sneering that he didn't want to chat with a Venezuelan. Apparently, his divine mission was to kill Venezuelans because they're attacking and are killing Cubans. A logic so warped it could star in its own conspiracy podcast. Police were alerted, and the clerk, acting as an amateur detective, later spotted Gonzalez strolling north and frantically flagged down the police. The cops, unimpressed by his self-appointed deity status, detained him at gunpoint and rummaged through his backpack, finding a handgun matching the clerk's description and a curious collection of gold and silver coins, like he was prepping for a pirate-themed pawn shop heist. When an officer attempted to read Gonzalez his Miranda rights in Spanish, he interrupted with the bold claim that God is my lawyer and he's King David. Not stopping there, he allegedly tossed out some unhinged threats, promising the arresting officers would die, their vehicle would burn, and only their ashes would remain. Talk about a flair for the dramatic. Now, guess what? Mr. Gonzalez was charged with improper exhibition of a firearm and aggravated assault with the intent to commit a felony. And Mr. Gonzalez now lounges in the Miami-Dade County Jail on a $5,000 bond, probably pontificating about his divine right to terrorize deli clerks. Just another day in the random acts of violence category, where the only thing more dangerous than the weapon is the ego. Can't make this stuff up, ladies and gentlemen. How about an update on that David guy that spells his name with a 4? Oh, look, more unverified screenshots. That's right. Well, here we go again, folks. The internet's favorite pastime, dragging celebrities through the digital mud, has found its latest in the target in David, spelled with a 4, the crooner whose real name is David Anthony Burke. Now, apparently performing at Lollapalooza wasn't enough to keep him in the headlines for the right reasons. Nope. Now we've got a screenshot because what's a modern scandal without some blurry context, free text floating around the cesspool of social media? Well, police are still poking around the tragic death of 17-year-old Celeste Rivera Hernandez, found deceased in Burke's car last month. No, he's apparently not a suspect yet, but try telling that to the online sleuths who have already convicted him in the court of public opinion. Now, we give him the presumption of innocence, but you got to admit, a little weird. You didn't realize your car was missing. And oh, by the way, where's your girlfriend? Anyway, the latest fueled the fire, alleged in 2023, chats with another minor, which, surprise, surprise, nobody can confirm are real. But who needs facts when you've got Reddit and Twitter to keep the rumor mill churning? Some guy on Twitter, now X, who claims he once shared a coffee with Burke or something, dropped these supposed screenshots, and they allegedly show Burke waxing poetic about wanting a public relationship, But oops, it's got to be a secret because the recipient still had a couple of years of high school left. Classy. The internet's split, as always, half screaming groomer and the other half preaching calm down. Screenshots can be faked. Gee, what a nuanced and productive discussion we're having. Anyway, Burke's keeping his lips sealed, which is probably the only smart move that he's made thus far. Meanwhile, he's lawyered up with Blair Burke, the legal eagle who saved the likes of Harvey Weinstein and Lindsay Lohan from their own little messes they got themselves into. And if that doesn't scream, I'm ready for the storm, nothing does. The police, they're just chilling, not confirming anything about these messages or whether they're digging through Burke's phone data. Hernandez's family, meanwhile, just laid her to rest, but to be sure, let's keep speculating about texts instead of giving them peace. So here we are waiting through another day of unverified claims and online outrage. Will these chats turn out to be real? Will they land Burke in hot water, or will they fizzle out like every other storm? Stay tuned, because the internet never sleeps, and neither does its appetite for drama. We'll bring it to you as it comes, ladies and gentlemen. Hey, when the guy spells his name David with a 4, you really got to wonder. Maybe somebody's got to fill me in why it's spelled that way. Next on the docket, a middle school teacher who's in jail for doing terrible things to a 15-year-old. Well, he got killed in prison. Yes, shocking, isn't it? Ernest Nicholas, a 60-year-old middle school gym teacher with a stellar record of repeatedly raping a 15-year-old girl, has met his untimely demise behind bars. Who could have predicted such a twist of fate? Found unresponsive in his cell at the Green Correctional Institution in Maury, North Carolina, about 6:50 a.m. on Sunday, the disgraced educator was pronounced dead just a half an hour later. The prison naturally went into lockdown to contain the chaos of this poetic justice. Now, Nicholas, convicted of statutory rape back in 2011, and slapped with a 15-year sentence, was apparently counting down the days until his September 2027 release. But alas, enter Wilbert Baldwin, a 41-year-old gentleman already serving time for second-degree murder since 2010, decided to expedite Nicholas's exit from this world. And then on Tuesday, the Greene County Sheriff's Office graciously issued a murder warrant for Baldwin because, paperwork must be done. And let's rewind to Nicholas's glory days at Ransom Middle School, where he was charged in 2009 with statutory rape and a delightful assortment of other sex offenses. According to the search warrant, Nichols spent 6 months starting in February of 2008 assaulting the teenager, who wasn't even a student at his school, because why limit your depravity to the workplace? In a charming twist, he allegedly watched her have consensual sex with another male, and ever the multitasker posed as his teenage son on Facebook to send her creepy messages. Shower updates and fictional sex stories were apparently his preferred topic of conversation. And he had the audacity to instruct her to tell anyone who asked that she wanted to be with him. How classy. Investigators clearly have a field day, seized videotapes, a camera, photos, and sex toys from Nichols' Huntingsville home, where all the assaults took place. When confronted by the victim's mother, Nichols, a married father of 2, reportedly called himself a pig. How refreshingly self-aware. At his hearing, he played the clueless card, refusing a plea deal, babbling about not being a straw man, and needing a bailiff to restrain his theatrics. Truly a model defendant. Now, as the Green Correctional Institution dusts itself off from lockdown, Nichols' death is still under investigation. Mr. Baldwin, meanwhile, has been shuffled off to the Department of Adult Corrections to continue his sentence, murder warrant in hand. Justice, it seems, has a funny way of sorting itself out in prison, doesn't it, ladies and gentlemen? And next, a little more celebrity news. Ex-Southern Charm darling Kathryn Dennis lands in the Clink for some DUI shenanigans. Remember her? Yes. If you ever watched Southern Charm, she was on in the early days. Hot mess, totally. Just had a way of just always getting herself into a certain amount of trouble. So the heiress to South Carolina's glorious Political legacy scores a month-long vacation in the county lockup. Ah, yes. Because nothing says charming Southern belle quite like a stint in the slammer. Now, Kathryn Dennis, the 33-year-old beacon of reality TV elegance from Bravo's oh-so-refined Southern charm, has graciously returned to her favorite accommodations behind bars. Now, she waltzed into the Berkeley County Detention Center at precisely 6:54 p.m. on Friday, October 3rd, to kick off her luxurious 30-day sentence. This little escapade stems from a Goose Creek Police Department arrest that was apparently the height of sophistication. Credit where credit's due. The scoot first dropped on Jameson Moyer from the local Charleston television station out there. This conviction, a mere 16 months after her stellar performance in May of 2024, where she allegedly played bumper cars with another vehicle at a stoplight, clocking it just before midnight on the 20th. Charged with her first offense, DUI and toting an open container. How utterly original. Anyway, officers responded to a motor vehicle collision with injury at the highway there at Highway 52 and Stephanie Drive, were treated to bystander tales of Dennis possibly being impaired, complete with that unmistakable perfume of alcohol wafting from her. How thoughtful of her to provide such sensory details. Upon closer inspection, the cops noted her glossy eyes and the aromatic hint of booze, even as she insisted she abstained entirely that evening. Post-arrest, a vehicle rummaged uncovered a charming assortment of mini Fireball bottles, some conveniently emptied. She politely declined a breathalyzer, but later confessed to imbibing way earlier. And at the hospital, she couldn't quite pinpoint when the fender bender occurred. Memory like a steel trap, clearly. And just 6 weeks back, Orangeburg County Larry Patrick Griffin decided to sue over the ordeal, claiming Dennis's conscious decision to drive while under the influence caused him grievous injuries, agony, and property woes. He's angling for a jury trial, actual damages, punitive slaps, and court costs, because why not add a little lawsuit to the mix of extra flair? Before this gem, Dennis starred in the ongoing investigation for a hit and run that dinged a Low Country sheriff's deputy 2 years prior. Her 2022 Ford Bronco allegedly clipped the officers directing traffic outside of an elementary school there in Moncks Corner, South Carolina, about 7:30 a.m., then vanished, piloted by the white female with dirty blonde hair. Miraculously, no charges materialized. What a fortunate coincidence. Of course, Dennis hails from South Carolina's most illustrious political dynasties. She descended from luminaries like South Carolina Senate President Rembert Dennis and even former U.S. Vice President John C. Calhoun. Plus, she enjoyed a lengthy romance with ex-state treasurer and Southern Charm sidekick Thomas Ravenel, who also went to prison for dealing drugs, with whom she shares two offspring, Kensington Calhoun Ravenel and St. Julian Rembrandt Ravenel. That doesn't speak of royalty. I don't know what does. Recently, she emerged victorious. Wait, no, she lost a bitterly contested custody fight because her track record just screams stability. And oh, look, who's back in the slammer? Deanne Haney, a 63-year-old former Texas City Commissioner, has once again proven that some people just can't help make spectacularly bad decisions after causing a horrific crash in 2017 that snuffed out the lives of Doc Van Lee and his son, Hong Fook Lee. Haney was handed a laughable lenient sentence back in February of 2024. 10 years of probation for 2 counts of criminally negligent homicide, because apparently killing 2 people with your Ford F-150 only warrants a slap on the wrist and a symbolic 1 day a year jail vacation until 2017. How touching. Prosecutors, understandably miffed, have stated that they thought prison was more fitting for someone who obliterated a family. But no, the justice system decided Haney deserves a second chance. Spoiler alert, she blew it faster than you can say reckless driving. And back in 2017, Haney was cruising down Interstate 45 near the Galveston Causeway Bridge when she veered off the road and plowed into the Lee family, who were stopped on the shoulder fixing a loose piece of plexiglass. Police initially suspected marijuana use. Haney even admitted to smoking some, because who doesn't love confessing to cops? But lab tests later showed no significant THC in her system. Pity, that might have at least explained her catastrophic lapse in judgment. Fast forward to September of 2024, and Haney's back at it, allegedly driving like a bumper car champion at 4 a.m. A witness reported her swerving and slurring, screaming into a void near a park, and possibly auditioning for a one-woman melodrama by rolling around on the ground. Haney's excuse, she was chasing people who attacked her. Sure. D. And I'm chasing a Pulitzer for this rewrite. Anyway, police noted her bloodshot eyes, alcohol-soaked breath, and wobbly balance despite her claim of just one beer and one shot. Right? Officers weren't buying it, and neither are we. After refusing a breathalyzer because that's what innocent people do, Haney was slapped with a DUI charge. But wait, there's more. She also couldn't be bothered to complete her court-mandated community service, 16 hours a week. Apparently, that was way too much effort for our former elected official. Completing community service is such an easy thing to do, said the prosecutors, yet somehow Haney fumbled that layup. And then on Friday, Judge Jeff Jones of the 122nd Judicial District Court had enough of Haney's nonsense. You don't seem to have ever taken this seriously, he said, probably while resisting the urge to roll his eyes. I'm not giving you a third chance. And just like that, Haney's probation was revoked, and now she's staring down a 10-year prison sentence. Maybe she'll finally have some time to reflect on her stellar life choices. Haney, who clung to her Texas City Commissioner seat after the 27 crash, only to lose in 2018, has officially cemented her legacy as a cautionary tale. Next time, maybe don't treat probation like a suggestion. It's a legal order. Next on the docket, this day in legal history. October 8th, 1793, the death of John Hancock, one of the American founding fathers, merchant, and statesman who served as president of the Continental Congress and signed the Declaration of Independence in big, bold letters because he said, by God, if they're going to come kill me, they might as well be able to read my name. Wrote his big John Hancock on the Declaration of Independence. And October 8th, 1934, an undocumented German immigrant by the name of Bruno Hamptmann was indicted for the murder of flying pioneer Child Lindbergh's infant son for the kidnapping and murder. On 1956, on this day, the United States Supreme Court hears argument in Yates v. United States, a key First Amendment case limiting the Smith Act's application to speech advocating overthrowing the United States government. And on this date, in 1988, the United States House of Representatives votes to begin impeachment hearings against President Clinton for lying about his affair with Monica Lewinsky, obviously invoking the constitutional impeachment process. And yes, he didn't get impeached, but he did get disbarred. He did get disbarred for lying. You know, you have to define what is kind of responses. Legal quote of the day: learn the rules like a pro so you can break them like an artist. Not really a legal quote, but it's you got to know the rules of evidence. So you got to know the rules in which to play by, so you can break them like an artist. Pablo Picasso said that. And finally, our dumb criminal of the day. Ladies and gentlemen, gather around as we crown the undisputed champion of criminal idiocy, the one and only William Kennedy, for Oscar-worthy performance in How to Snatch Defeat from the Jaws of a Crime. In a move that screams genius at work, this Pennsylvania mastermind decided to spice up his kidnapping plot by handing the car keys to the victim. Because, you know, what could possibly go wrong when you ask your terrified captive to take the wheel? Bravo, sir, for clinching the Dumb Criminal of the Day award with this dazzling display of brain power. How did we get here? On October 1st, Scottsdale police were called to Jennings Avenue for a welfare check after concerned family members hadn't heard from the victim, Nelson, following a domestic incident with our star, Kennedy. Officers found an open door, Nelson's phone abandoned inside, and no sign of her. Classic signs of a situation gone south. Now, according to the criminal complaint, Kennedy allegedly drove Nelson to a remote wooded area where he thought it'd be cute to hold a gun to her head and force her to camp out overnight. Truly a romantic getaway for the ages. But here's where our hero's brilliance shines. By morning, Kennedy, apparently tuckered out from his villainous antics, decided he was too sleepy to drive. So in a stroke of pure, unfiltered genius, he asked Nelson to slide into the driver's seat. What did he think she'd do? Take him for a scenic tour through the countryside? Maybe stop for coffee? Nope. Nelson, clearly the brains of the operation, recognizing her surroundings, floored it straight to the Scottsdale Police Department. She bolted from the car and ran inside, leaving Kennedy to realize his Oscar-worthy plan had just crashed and burned. In a final touch of class, he allegedly shouted threats to burn her house down before peeling out, because nothing says "I meant to do that" like a dramatic exit. Anyway, the district attorney has slapped Kennedy with felony kidnapping charges and a slew of other offenses because apparently being a criminal mastermind isn't enough to dodge consequences, but he's still on the lam. So he's also considered armed and dangerous. So if you spot this luminary, do the world a favor and contact the Scottsdale Police Department at 724-887-8220. Congratulations, William Kennedy, for proving that when it comes to dumb crimes, you're in a league of your own. Take a bow, just not near a police station. All right, ladies and gentlemen, that's all we have for you today. Thanks for joining us. We'll see you next time. And remember, the Constitution matters.